Welcome, everyone. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar Association, and we're very excited to have you with us today, and also our speaker. I want to let everybody know that on September 23rd, we have a program on commercial leasing. Mike Meyer from Glazer Weil will be speaking. Michael is a national authority on commercial leases, and he's going to talk to us about changes in lease language, and in particular, what has happened that may be new or that you'll want to look at due to the COVID-19 pandemic. In October, we have a program on residential construction disputes. Jason Adams of Gibbs Giddon is going to go over the statutory requirements that now apply to those types of disputes and strategies that you may want to employ in contractor or homeowner types of disputes. For today's program, I'll be monitoring the chat. Please put your questions in the chat and try to keep track of those, and hopefully we'll have time to answer them all and at the appropriate time during the presentation. Your MCLE certificates are going to be mailed out by email within 24 hours. Beverly Hills Bar staff is very efficient in getting those out to people. The program materials you received a link to in the reminder email that came 1 hour before the program, and the staff from the bar is also now posting a link to the program materials in the chat, so you can access the materials there. It's our great pleasure to once again have someone coming from the California Association of Realtors who has graced us every year for many, many years with a speaking engagement to talk usually about their new forms and also about other developments that are taking place. And we're fortunate this year to have somebody new joining us, which is Jana Gardner. And Jana, thank you for coming. Jana is a senior counsel with C.A.R. Since joining C.A.R. in 2014, 7 years ago. She has primarily focused on advising members through the legal hotline. But in addition to that, she presents legal updates, outreaches, teaching classes on disclosures and the residential purchase agreement, which of course is so prolific in residential transactions in Southern California. In addition, Jana prepares legal resources such as legal Q&As and quick guides, and also co-hosts C.A.R.'s Legal Matters podcast. Jana received her bachelor's degree in social science from San Diego State University and her Juris Doctorate from the University of Southern California. And as you've seen tonight, today's topic are some new C.A.R. standard forms and also a couple of tips about advising agents in a hot real estate market. Jana, thank you very much.
Thank you so much for having me. Hello, everybody. Thank you, Howard, for that wonderful introduction. And thank you for having me here today. Like Howard said, I believe in years past, my colleague Neil Kalin has been here to give you a rundown on all the new forms and sort of the hot trends in residential real estate legal issues. Neil has graciously allowed me to be here in his stead. One of the reasons for that being that we are in the middle of one of our busiest times, which is getting ready to roll out new purchase agreements at the end of the year. So I'm going to be talking today about the new forms that we have released for use by realtors over the last 12 or so months. You'll see there's really only 3 new forms that have been released. And one of the main reasons for that is because we are about to release a brand new residential purchase agreement, and with corresponding changes to all of the rest of our purchase agreements, commercial, residential income, vacant land, all of those. So that is going to be our focus for the third and fourth quarter of this year. But for now, I am here today to go over the 3 new forms we have released over the past 12 months, the first of which was a fair housing and discrimination advisory. We also have a transfer of listing agreement for transferring listings between brokerages when either a client wants to change offices, or which may or may not be connected to an agent changing offices. And then probably the bulk of my time I will spend going over the new fire hardening and defensible space disclosure advisory and addendum, which is a new, somewhat complicated form that we put out in response to a new, somewhat complicated law that has gone into effect in phases over the past 6 months or so. And then with some time at the end, I just want to highlight some of the big issues that we are seeing. Obviously, it's been a crazy, to put it mildly, residential real estate market over the past year and a half. And as the market has gotten more and more competitive, we have really noticed a trend of some very common mistakes, missteps, sort of common errors that we see agents making that I just want to highlight if you find yourself advising agents who might be getting in a little over their head in this incredibly competitive marketplace that we find ourselves. So before that, though, I'm going to run down the new forms. Like I said, the first one, the Fair Housing Discrimination Advisory, which is FHDS form, and it was released last October. The Transfer of Listing form, which came out in June. And then the Fire Hardening and Defensible Space form, which came out in May because it was tied to a law going into effect as of July 1st. And we actually had briefly another new form. We had a standalone home hardening disclosure and advisory that's already come and gone. It was introduced at the beginning of the year for the first phase of this law that was in effect from January to June, and it has already been replaced. So not even going to worry about that one. It's come and gone since the last time you all had a forms update, but it was replaced by the FHDS form. So starting with our first form, the Fair Housing Discrimination and Advisory. This is a new advisory form that is currently attached to 21 different C.A.R. standard forms. So 10 of our purchase agreements, basically all of them, residential income, manufactured home, even commercial, vacant land, all of these forms, we just pre-bundled this Fair Housing Discrimination and Advisory to make sure it's getting in front of agents and clients and consumers. It's also bundled with listing agreements, buyer representation agreements, and quite relevantly, landlord-tenant agreements, the lease, and the lease listing form. And by bundle, that simply means that if an agent goes into whatever library they use to access C.A.R. standard forms, they are going to, and they pull up one of these agreements, one of these contracts, they're going to see this Fair Housing Disclosure and Advisory with it. And this came out last fall, and it was released basically in conjunction with what really was an across the board additional emphasis on fair housing practices statewide. As everyone was aware, last year there was a dramatic increase on fair housing, racial justice, concepts like that in particular, and there was a dramatic rise in an awareness of fair housing issues and, frankly, fair housing claims that were being made to the DFEH, the Department of Fair Employment and Housing, and that we were seeing brought against sellers, landlords, and real estate brokers. So in order to better educate everybody about what their fair housing obligations and rights are, and also to help to protect real estate brokers so that they are properly advising their client, well, one, properly understanding themselves about what their obligations are under fair housing law, and properly advising their clients that they are covered by fair housing law and have certain rights and obligations. Hence, we created this FHDA form. So it's 2 pages. It's a whole lot of dense printing, but as I always say to agents, I know when they put these kinds of documents in front of clients, it's a lot of just scroll, sign, scroll, initial. But every time one of these forms is created and we put it in our library, it is almost entirely in response to lawsuits and claims and things like that. And so there really is a reason and benefit to get this document, for an agent to get it in front of their client and make sure it is read and go over it with them, frankly, and say, hey, let's talk about this if you have any questions. And so, yes.
Yeah, I have a question for you. If I understand what you're saying correctly, this is something that C.A.R. has put together because they feel it helps protect the real estate agents and brokers involved in a transaction. And of course, when these packages are put in front of a buyer or a seller, they somehow have the idea that they're required to sign these. But yes, I suppose with a form like this that is not prescribed by statute, somebody could technically say, this isn't required and I'm not going to worry about this form.
Mm-hmm. Absolutely. And that has happened, or, that does happen, I should say, on occasion. I have definitely spoken with brokers who say, like, my clients won't sign this, or do they have to sign this? And you're absolutely right that no, it's not a statutory form. Generally, whenever we create something, not always, but for the most part, if it says advisory in the title, typically a risk management form that is in place to largely protect brokers, although also their clients in certain respects, and is there to make sure that this information gets in front of somebody. But yeah, if a client objects and says, I'm not signing this, they're not required to do so.
So when we see advisory in the title, then likely that's something that's not statutory, but
Yes.
something that C.A.R. Believes agents should be using.
Yes, yeah, that's 99% of the time I would say that is correct. Advisory is sort of a shortcut for risk management, advisable, but not prescribed by statute.
Thank you.
Sure. So yeah, like we just emphasized, definitely here for educational purposes. There isn't, at least not yet, any law or statute that says this information has to be provided to clients, although the benefits are definitely there. A lot of this information at the top is general advisory information, just a statement of the belief in equal housing access for all and what the fair housing law requires, and then a list of all the various fair housing laws that do apply: federal, state, FEHA, UNRU, and then ADA is applicable, other fair housing laws is applicable, and then trying to let people know there are legal remedies for unlawful discrimination, and that you could face a variety of consequences if you engage in discriminatory behavior. And then one thing that I have found to be very illuminating for real estate agents and brokers as well as their clients is a listing out of the protected classes and characteristics under California fair housing law. People have a really good sense of, I know I can't discriminate based on race. I know I can't discriminate based on religion or things like that. But, something, for example, like source of income, which in the landlord tenant space is a real significant issue. And many landlords have no idea that they cannot discriminate against a tenant or prospective tenant based on their source of income, whether it's government aid or assistance or anything like that. Most notably, Section 8, now specifically a protected source of income under fair housing law. Landlords can no longer refuse to rent to a tenant based on the fact that they receive Section 8 subsidies or refuse to cooperate with Section 8 programs. So very important to get that information out so that people understand it. And then, medical condition, veteran status, just things that people don't necessarily think of. Citizenship, they may not be aware these are protected. So I found this very useful for highlighting that for everyone involved in a real estate transaction. Then there's just a couple of notes for agents to highlight for themselves and their clients that, real estate licensees, the Department of Real Estate requires fair housing training and the following of fair housing laws by licensees. Realtor organizations, the NAR, National Association of Realtors Code of Ethics, has specific prohibitions on discrimination. So a realtor who engages in fair housing discrimination will be violating a variety of laws and could impact their license on top of being an ethical violation as a realtor. And then another really good piece of educational material in here is reminding people the vast sort of expanse of who is covered, who is considered a housing provider, or who is covered under fair housing laws. Most people get that landlords have to follow fair housing laws. That's kind of the easy ones, but not everyone realizes that sellers as well, that you can't discriminate even when you're selling your property as opposed to renting it out, that real estate licensees are themselves covered by these laws and cannot discriminate. And it's not a defense to say, well, my client told me to, that they have their own independent obligations to protect fair housing. HOAs is another one. Many people don't realize that HOAs are covered by these laws. And so, just because something's in the CC&Rs, if it's just absolutely discriminatory, that's not going to be something the HOA can get away with. And then again, property managers, even if you're subletting a property, for example, just really flagging that there's a wide variety of people who are covered by this. And then I would say that what we have here in paragraph 8 is probably the most significant portion of this entire form, and definitely has provoked the most discussion. And what we've done is given a couple examples of conduct that is not motivated usually by discriminatory intent, basically common practices that people think they're trying to do something good or that's something okay, but they could sort of stumble backwards into fair housing discrimination. And the biggest one of those is the practice of providing what are called buyer love letters, or sometimes buyer intent letters. This has been a somewhat common but controversial practice for as long as I've been at C.A.R. and even longer than that. You're probably familiar with the practice of buyers who want to, especially in a very competitive, low inventory market like we're in right now, buyers who want to write a letter to the sellers saying, here's why you should accept my offer. I know you have 50 offers on your property, but we're a nice family. We'll take such good care of the house. The yard would be perfect for our 3 kids and our 2 dogs. And here, look at this picture, this photograph of our nice family. And it's typically very well intentioned. And frankly, it's a practice that, from what I gather, a lot of agents instruct their clients to do. But of course, as soon as you start divulging personal information as a buyer, and of course, providing photographs, and start giving clues to some protected characteristics, like race and other issues that may fall under that, you start running into potential really sort of tightrope walking fair housing violation issues. If a seller accepts a particular offer and that offer included a letter that showed certain characteristics about them that maybe another offer as a member of a protected class didn't get their offer accepted, even if there was no ill intention, it raises the specter of discrimination and can really put everybody in a very difficult position. And so the advice that we give, and that is basically contained in this document, is, if you're a seller, you really don't want to look at those letters. A good practice would be for a listing agent and a seller to discuss in advance. If we get these letters, they're very dangerous to look at. They put you at a big liability risk. Should I reject them? Should I put them aside? Let's not consider them, and just basically draw a line from minute one saying, we're going to look at the content of the offers. We're not going to take into account personal letters from buyers, just so that it doesn't even have the appearance of impropriety, doesn't have the appearance of discrimination. This is a very controversial matter. Like I was saying, this is a very common practice. And to be quite frank, there are some agents and some other attorneys I've spoken with who think that that it's not necessarily discrimination. What about instances where people write a buyer love letter and someone maybe chooses to sell to someone who's from a protected status? It really is a thorny issue. And it's frankly one that I don't think is going to be going away anytime soon. Just, I believe, a day or two ago, found out that the state of Oregon passed a law going into effect in 2022 that is outlawing this practice. Under their agency law for real estate licensees, they are making it illegal for listing agents to pass on buyer love letters, buyer intent letters to their clients. So I don't know if that's a trend, if anything like that would happen here, but it's definitely something we have our eyes on, because it's just probably the most common practice that puts everybody at a lot of liability risk, but is addressed here in this forum to try to make everybody aware and to really give agents an opportunity to have this conversation with their clients. And then the other unintentional discriminatory activity that is mentioned here, and I get this one a lot from property managers, which is, an elderly tenant applies for a property that has a steep staircase, or a family with small children applies for a property with a pool, and they want to decline them, saying, I don't think it's a good fit for them. It's for their own safety, and reminding people that you can't make that determination for tenants. If they've applied, and you don't get to decide that what's in their best interest for their safety as much as a landlord would like to have that option. And then just running through the rest of this somewhat quickly, there's a laundry list of your more on its face obvious discriminatory actions, steering, blockbusting, advertising a preference for members of certain protected classes or not, inquiring about protected characteristics, denying renting or selling to somebody on these basis. More of your straightforward, everyone knows that sounds at least like a fair housing violation. And then also, on the flip side, we tried to include some examples of positive practices. So it's not just, here's all the things you cannot do, but try to give some examples of positive practices. reminding people, set objective criteria and stand by those, compile complete and objective information on all prospective buyers, all prospective clients, treat everybody the same. It seems obvious, but provide the same professional courtesy to anybody who inquires about a property. Don't put any sort of preference in your advertising based on any protected characteristics, language spoken, religious, faith, anything like that. And then, recommending that people really, to the extent they can, limit their selection process to looking at subjective information, maybe even using a summary document or a spreadsheet where you look at either tenant applicants or offers based on the strength of the offer itself, maybe not even looking at personal information like names and things that could give away any sort of preference or protected characteristic. So that's all there, advisory, educational, but I think with a lot of really important information. From my experience of talking to agents and brokers on a daily basis, they know fair housing law exists. Most of them know it applies to them, but very few of them really understand what it means. And so we have also listed here a ton of fair housing resources that are available to people. And this is, like I said, was released in conjunction with us having a lot of resources, multiple webinars, multiple other educational opportunities. And so we try to really continue to get that message out to brokers and agents so that they are on top of things and aware of what laws they need to be following in order to protect themselves, protect their clients. And then there's a list of exceptions, but that's there basically to remind them there are certain examples, certain exceptions of things that don't apply, roommates, things like that on a very narrow basis. But we try to say, don't decide for yourselves, consult with an attorney, obviously, on a case-by-case basis if you think an exception may apply to you. All right. Is there anything else on this before we move on, Howard?
Yeah, one question. You mentioned in the items that could be violations, immigration status.
Yes.
One would think that an owner would want to know if their person renting from them is in the country legally, because it is a financial risk to them if you're renting to somebody who is not here lawfully. So is that something that's prohibited from inquiry?
Yeah, it's a really great question, because that is, I think, one of the protected statuses that is very tricky to suss out, because there are objective reasons, like you said, that could be relevant. And so the way that I've seen this interpreted and the way that I advise property managers who might be screening tenants in this way is you obviously can do your objective financial review. And so if someone doesn't have a social security number, they don't have a credit history, they don't have the kinds of things you would normally be looking for financially, then absolutely that can be the basis for denying them. And so often these things will go hand in hand. And so, but if they have a tax ID number and they have tax returns and they have a credit history and all of that, and they just happen to not be in the country illegally somehow, then their immigration status on its own cannot be the basis for denying them. But if their immigration status results in you being unable to verify their creditworthiness, then the creditworthiness is still a valid reason to deny an application.
Thank you.
Sure. All right. So on to the second form we're going to talk about, which is the transfer of listing agreement, form TOL. And this is one of our most sort of historically requested forms. This has sort of been a long time coming, and it's very exciting for all of us that it's finally here. Essentially, what the situation occurs is that agents change offices, and an agent signs up a listing with their clients. Maybe it's somebody they just found through farming, or maybe it's even a personal, family or friend or something like that. And then during the listing period, that agent wants to hop on over to another brokerage. And that ends up causing quite a complication because the listing belongs to the broker. And, just legally, the way agency law works, the way the contracts are all set up, that contract belongs to the broker. And a lot of agents are often, and clients too, are often under the misinterpretation that they can simply just, move on over to another office and take it with them. And it's not that easy. And agents find themselves getting into hot water. It's a DRE violation. If you move your license over, you can only do licensed activity for the broker where your license actually hangs. And so if they don't move the listing over and they keep working on that deal, now they have a licensing violation. Plus, it's just liability for both brokers to have this sort of in between, one agent working on it. It's not for that broker. That other broker is not supervising. It totally messes up everybody's E&O insurance coverage if there ends up being a problem. And what it really boils down to is that often the principal, the seller, doesn't even realize that, frankly, their personal relationship is usually with their agent. They may never even meet the broker if it's a large scale brokerage. So we find, so there was often a problem when an agent switched an office and they wanted to take the listing, and there was really no way to do that other than just to cancel the original listing and sign it up with a new broker, which you can obviously still do, and people have done. But often, understandably, that original broker, it does not want to cancel unless they have certain assurances about compensation that they're going to receive, or just their liability going forward. So this transfer of listing form is here to accommodate that and facilitate the transfer of a listing, sort of usually in the interest of keeping the client happy, but also protecting the rights of all the brokers involved. And so this can be used for any listing agreement, residential listing, commercial, lease listing. Anytime someone has a listing agreement, this form can be used to transfer it over. And it does a couple of main things. First, and often most importantly to the brokers involved, it gives 3 options for how compensation consideration is going to be provided to that original broker. So either the seller who is moving to the new office can agree to just compensate the first broker a flat fee payment for their services rendered, out-of-pocket expenses incurred up until this point, and call it a day with that. Or the new broker can take on the compensation, saying, okay, first broker, thank you for releasing your listing and giving it over to me, and I will compensate you either, basically in the form of what would normally be considered a referral fee, as a percentage, of my compensation when I close the deal, or as a flat fee when I close the deal. Either way, new broker can say, when the deal closes, I'll send some compensation your way for the time you spent and your cooperation in transferring this listing over. And then beyond compensation really deals with liability and the practical effects of jumping from one brokerage to another in a mid-transaction situation. Principal is agreeing to terminate their original agency, and that the original broker has no ongoing agency relationship or obligation, and that they're getting an agency disclosure and establishing new agency with the new broker. If the parties are doing this when an offer's already been accepted and they are in escrow, which makes it that much more complicated. It does, though, sort of tell them how to accomplish that, how they need to modify, update the agency confirmation in a purchase contract, and update any information for escrow to move the transaction over. It addresses MLS issues, which is always a major concern for the agents and brokers involved in these transactions. They want to make sure that if they are taking over a listing, they can get that listing under their name in the MLS. And so the original broker agrees in this form that they will cooperate with that and either cancel out or transfer the listing to the new broker in their particular MLS service. There is a provision about trust funds. If in the event that the current broker is holding trust funds of any kind for the client, they will by default transfer over those trust funds to the new broker, or there's an option just to release them back to the client. Basically is an essentially non-issue if it's a listing agreement for purchase or sale. Thankfully, brokers don't handle deposits or trust funds or anything like that for the most part anymore. But if it was a lease listing, there could be a property management trust fund situation. So that's there just in case. And then one key thing about this form and the way it's structured is that it's an agreement between the original broker, the new broker, and the seller, the principal in the transaction. The agent themselves is not a party, but there is an acknowledgement that I would say 9 times out of 10, this transfer is happening due to an agent leaving an office or switching offices And so there is a place here to acknowledge that, give the name of the agent, clarify that the agent, if applicable, is no longer affiliated with the broker and maybe now affiliated with the new broker instead. And then some other just important procedural issues. The file, the documents are going to be transferred over as necessary. And then there is a release, basically releasing the original broker from any liability going forward on this transaction. So anything that arises after the time of the transfer, the seller is releasing the original broker from any liability for the future actions of the new broker who takes the transaction over. And then everybody signs off, and hopefully everybody is happy with their new office and moving forward with their new listing arrangement.
Jana, I see something that might be missing from this form.
Sure.
You have a transaction that starts in one brokerage and ends in another. It was originally put in the MLS by one broker with certain representations, and then somebody else takes it over. And I don't see a clause in here that discusses relative liability or indemnity between the original broker and the substituted broker if there's a lawsuit later by one of the buyer or the seller and they name the agents, where the original broker indemnifies the second broker for things that happened during the first part of the listing period, or vice versa, where the second broker indemnifies the first broker for things that happened during the second part of the listing.
Yeah.
So that seems to be an open issue that's sort of left to common law here, potentially.
Yeah, no, that's a very great point. And this is one of those times where it would be helpful if Neil was here, since he has a much more direct hand in writing the forms and he might have an inside scoop for you. I too seem to recall that might have been in this form at one point and didn't make it to the final version for reasons that I unfortunately cannot speak to. But I think you're right. I think that's absolutely still a sort of potential hanging issue of, something goes wrong down the road, buyers suing everybody. What is the relative liability between the two brokers? Maybe in revised version 2, but that's a very, very salient point about an open issue there.
Thank you.
Sure. All right. Okay, so now on to our third and final and far and away most complex form that I'm going to be talking about today, which is the Fire Hardening and Defensible Space Advisory Disclosure and Addendum. And this is the 1% of times where there's a form that says advisory in it, but it is also a disclosure and addendum and is statutory. So this form is absolutely required on a certain subset of all real estate transactions going forward. This form was created in response to a new law that was passed actually back in 2019. Assembly Bill 38 added 2 new sections to Civil Code Section 1102, specifically to address fire hazard and fire safety requirements and disclosures tied to the sale of real property. So unfortunately, I think this is just one of what we're going to continue to see be many new laws dealing with fire safety, fire hazards. Like Howard mentioned, I've been at C.A.R. for a little over 7 years now. And I would say for the past 4 or so years straight, ever since wildfire season sort of really, really got, it's been bad for a long time, but I think with the Napa fires starting back in 2017, it has just been expanding to an almost year-round issue of wildfires and how they impact real estate transactions. And, just in general around the entire state, I think nobody could really have missed that at this point. So there are 2 new laws specifically tied to the sale of property. The first is 1102.6F, a new civil code section that went into effect on January 1st, and it has to do with a required disclosure relating to home fire hardening retrofits. And then 1102.19 is the newest added section to the civil code in this area, which requires certain documentation of compliance with existing defensible space rules. I'll get into all of what that means in a second, because I definitely did not know what a lot of these terms were before I really had to get into researching and understanding this law. I know for a lot of people, if you live in a fire area, you might be very familiar with this, but for a lot of us, it's been playing catch up. So quick note on applicability: this law and this new form applies to sales of residential 1 to 4 unit properties that are located in a high or very high fire hazard severity zone, which is, again, a growing portion of the state, unfortunately. There, I'll show you a map in a second so you can get a visual of what that looks like if you're not familiar. I can also tell you that due to this law going into effect, I've had many, many meetings with some very nice folks at CAL FIRE talking about fire hazard severity zones and these laws and the enforcement and the implementation. And one thing they have let me know is that CAL FIRE is in the middle of a remapping process right now, specifically trying to address the fire hazard zone mapping and how it relates to wind patterns. And I think the short version is there's going to be a new map before the end of the year, and the fire zones are going to be even more expanded than they already are. So it's just going to continue to affect more and more properties, more and more transactions. For properties that are located in those fire zones, the home fire hardening notice and disclosure is only required if the property was built prior to 2010. Starting in 2010, building codes were generally updated so that these home fire hardening features became standard. But if they were built prior to that, then it's much more likely that the property is lacking these certain home hardening features. And then finally, a note about exemptions. Because these laws were enacted as part of Civil Code Section 1102, that is the section of the Civil Code where we get the real estate transfer disclosure statement, or the TDS law. And so the exemptions that apply, sellers who are exempt from supplying the transfer disclosure statement are also exempt from complying with these requirements. So if the property is being sold as part of a probate estate, or if it is the trustee of a trust, or successor trustee of a trust, most realistically, or REO transactions, bank-owned sales, and bankruptcy properties that are part of bankruptcy estates. Those sellers, those transactions will be exempt from this form in this law, just like they're already exempt from the real estate transfer disclosure statement in general. All right, so here's the map. This is sort of the north part of LA, as you can see. But everything that is in bright red or like pale red, those are your high and very high fire hazard severity zones. So it's a lot of area. You can see some of the more urban portions are not in any of these zones. And then anything that is in the light orange is a high zone. And there's little bits of yellow. And because this is sort of the north part of the county, there's some federal areas there for the Angeles National Forest as well. But just to get a sense that just because the property is located in a city, I think a lot of people don't think about this as applying to them, but especially here in LA, the Santa Monica Mountains and everything, we've got a lot of high fire hazard severity zones at play. Oh, and I have a couple of reference links here. That fire.ca.gov DSpace is CAL FIRE's defensible space law website that they go to for how to comply with this law. And then LA County has their own version as well. So just a quick rundown, very brief education in case anyone is coming to this cold like I was a few months ago. What is fire hardening? Fire hardening is the use of building resistant materials or instituting home features that protect a home from catching fire. Basically, wildfires are often spread by flying embers, which when there are gusty winds, a single flying ember can travel up to a mile ahead of where a fire is. And if that ember lands on a house that is flammable, then a fire can ignite. And it's one of the ways that we see fires jump so quickly and spread so fast. And so fire hardening, home hardening is a way to retrofit a property, not necessarily in an expensive way, but do some retrofits on a property to try to make it less flammable and reduce the likelihood that a flying ember could ignite the property and spread fire. And then defensible space isn't about the structure itself, like fire hardening is, it's about the area around the structure. It's about creating a buffer zone around the home or the structure on the property, so that there's not too many plants or other combustible materials close up. Obviously, to slow the spread of a fire if it's coming through a community, and then also to protect firefighters specifically. If firefighters are on the property protecting the structure, having defensible space makes it easier for them to do so. And defensible space is created out of 2 zones. There can be more, but generally statewide, there's a 30-foot zone and then up to 100 feet with different rules about what sort of landscaping you can have, how short your grass has to be, how spaced out bushes or trees need to be. So just a couple of visual aids from CAL FIRE. This readyforwildfire.org website is very helpful and educational if you want to learn more about all of these processes. This just goes through what the home hardening requirements are. And then this is a good visual aid of what defensible space looks like with those 2 zones. I will say one question that I get a lot is, well, what about your postage stamp lots? What about your tiny lot line properties? And, you know, maybe it's not as obvious as it might seem, but common sense does apply here, which isn't always the case, which is you're responsible up to your property line. So if you don't have 30 or let alone 100 feet between the edge of the structure and the property line, then you're only responsible for the defensible space up to your own property line. Neighbors, at least under the current state law, are not required to maintain defensible space for structures on neighboring properties, although there are some local localities that do require that. Some of mountainous Northern California counties that I have talked to do have those sorts of requirements, but the general rule is subject property only. So this is a quick look at what the fire hardening law requires, which is basically 2 things. One, there has to be a statement provided to the buyer that the property is located in a high or very high fire hazard severity zone, and that in order to better protect your home, you are encouraged to make sure that all these home hardening features are in place. And then also the seller is required to provide a list of certain features in the property that may exist that may make it vulnerable to wildfire spread, and to disclose which of those vulnerabilities are present on the property that the seller is aware of. So it's a seller awareness standard. Seller, are you aware of these vulnerabilities? And then I have also just noted here, not in effect yet, but we like to be prepared. Starting in 2025, this law is actually going to be expanded and sellers will have an affirmative duty to list out what retrofits they have done. So right now, it's just a list of retrofits that are missing, and the seller has to say if they know of any missing retrofits. But starting in 2025, sellers will actually have to say, you know, I installed double paned windows, I replaced my roof with less flammable materials, that sort of thing. And then this is the code section dealing with the defensible space requirements of this law. I'm not going to walk through it directly, but I wanted to have it here for you in the materials so you could refer back to it. But essentially, what this law does that is so, I guess, interesting is the nice way of putting it, somewhat confounding, is that in 1102.19a, it basically makes this statement saying that starting on July 1st, a seller of real property, subject to this article, has to do one of 2 things. If there's a local ordinance that requires obtaining documentation of compliance with defensible space law, the seller has to do that, provide that. Or if there's a local jurisdiction that does not have a local ordinance requiring obtaining documentation of compliance with the defensible space requirements, then, and there is someone who will conduct an inspection, then the seller will provide the buyer with documentation obtained in the previous 6 months. So you read the first half of this law, and it really sounds like this is a huge new point of sale requirement for sellers that should sort of massively disrupt real estate transactions in these fire zones. But then Part B comes along and says, okay, starting on July 1st, if the seller described above doesn't have the documentation of compliance, well, then the buyer can get it instead. So it is basically a shiftable obligation to the buyer. If there's a local ordinance in place, and it does say that the buyer and seller will enter into a written agreement for the buyer to comply. So if there's a local ordinance in place, the buyer will agree to comply with whatever the local ordinance is. If there is not a local ordinance in place, if we're just defaulting to the state law, then the buyer will agree to obtain documentation of compliance within 1 year after the closing of the escrow. So that is, from what we can tell at this place, probably going to be the most common option currently. I mean, as well, again, probably be more and more local laws passed, and this is always subject to evolution. But the law as it stands now, in the vast majority of transactions, buyers of property in these fire hazard zones, unless the seller has this documentation of compliance and can provide it ahead of time, the buyer will often be agreeing to go out and get the documentation of compliance within 1 year after closing escrow on the sale of the property.
Jana, who, if
Yes.
anyone, is giving such documentation of compliance?
Great question. So there are two, I'm going to back up a little bit here. So there are two types of fire zones. There are state responsibility areas and local responsibility areas. So state responsibility areas, which on this map are like the more faded colors, that's going to be typically your CAL FIRE, your state fire agency, CAL FIRE. They will come out and do inspections, and they will give you a certificate or documentation of some kind showing that the property is in compliance with the defensible space law.
And are they already doing this for people?
They are. So what they have done traditionally in the past, and again, this is something I just learned from my discussions with them, is that traditionally, this is something that they have done on a semi-regular basis. So before this law was enacted, they basically would go around, like they'd try to hit every property in their jurisdiction, I believe once every 3 years, to do the inspection and catch any violators and issue any documentation. But they have been gearing up big time. They knew this law was coming. They've been hiring inspectors. They launched their website. And so they are now responsive to requests for inspections. And I believe their plan is to now try to get to all the properties every year in their area. So in the state responsibility area, it's typically going to be CAL FIRE. And then if you are in a local responsibility area where this like bright red is on the map, then it's the local fire agency, which in most places will just be the fire department. LA County Fire does have a program for this as well. Previously, most of these local entities did not issue documentation of compliance. From what I've gathered from friends and colleagues who live in the canyons and in the mountains, they said that they would get either sometimes drones flying around to look in their yards, or they would get the fire department coming door to door. But in the past, they have only really notified you if there's a problem. Like they wouldn't give documentation if you were in compliance. They would just cite you if you were in violation. But again, under this new law, the expectation is that those local agencies, local fire departments who were supposed to be doing these inspections the entire time, will start issuing documentation of compliance.
They do this without charge?
Yes, they do this without charge. One thing I should note, because CAL FIRE has brought this to our attention, is there, as you might expect, starting to be inspection services that are cropping up and offering for a charge defensible space compliance inspections. And these are for-profit entities, not governmental entities. And, you know, it's not that there's no use for something like that. Someone might want that for informational purposes, but you know, it could be viewed as misleading to have a company out there saying, we'll do defensible space inspections, but they're not an approved government entity. They charge you, and then their documentation of compliance does not meet the legal standard because it's not coming from the fire
agency. Thank you, Jana. Thanks for the answers. I'm sorry if I'm interrupting a little.
Oh, sure.
We're at 1:20 now. So.
All right, let's keep moving. So let's get to the form itself. This is what the form looks like. It comes in two parts. The first part deals with the home hardening requirements and also general applicability. already ran down the applicability. I will say that part 1B here, where to locate information, that has been far and away sort of the main question I have got from brokers and agents, and to the extent that I've spoken with consumers as well. How do you know if your property is subject to these laws, if you're in a high or very high fire hazard severity zone? Most of the time, that's going to mean looking at the NHD report, the Natural Hazard Zone Disclosure Report, that is ordered with basically every transaction. So that's going to be the easiest way to tell. But you can also go, I have the web address here for that map image that I was showing you. You can go to that map and put in a property address, and it'll show as well where you fall on the map. And you can always put a phone call into CAL FIRE or your local fire agency to find out for sure. So once you find out that the law applies to the sale and this form needs to be provided, paragraph 3 here has the required home fire hardening information that I discussed. It has the statutory notice, and it has the list of vulnerabilities, and gives seller the option of checking, are you aware of various vulnerabilities in the property? If they don't know anything, theoretically they could check no. If they know, for example, that they have, say, a wood shingle roof or single paned windows, then they need to be checking those boxes, disclosing about those vulnerabilities on the property. And then part 2, come on. There we go. Part 2 is the actual defensible space portion of this form. Explains the defensible space requirements, and then it breaks down those 4 options that were in the civil code as 4 different options, letting a buyer and seller know, okay, here are the ways, the options you have for complying with this law. It defaults to that one that I said we think is going to be the most common, which is there's no local ordinance requiring you get this documentation. So buyer, you're agreeing that within 1 year after closing, you'll provide it. Or you could check too, if seller either coincidentally has had an inspection and got documentation in the past 6 months, or potentially in a less crazy seller market, this could become a bit of a pre-listing, pre-sale tactic for sellers to say, let me just get the inspection, get it, and I can just provide that to buyers to smooth the transaction. That would be option 2. And then options 3 and 4 are for where there is a local requirement. Option 3 says if the local ordinance permits buyers to comply after closing, that's what the parties will do. And then option 4 is what for now is going to be far and away the least common situation, which is a true point of sale requirement. So if there is a local law that requires getting this documentation, it requires the seller to do it as a condition of closing escrow, then that's where box 4 comes in. To my personal knowledge, the Tahoe Truckee Fire District is the only place in the state right now that has a true point of sale requirement. If you're selling property up in Tahoe and Truckee, then sellers have to make sure the property is in compliance with defensible space law at the time the property is sold. Everywhere else I'm familiar with, it can be shifted to a buyer obligation. And then if there is documentation being provided, there's a space for the seller to disclose to the buyer what the local agency is that provides the documents. And again, I have the link here to the CAL FIRE website. So if you want to poke around and see what it looks like to schedule these inspections or what their information is, that's a very good resource. All right, so that's it for the forms. And I know we have just a couple of minutes left, and I do want to be respectful of everybody's time. I know we're all busy and we're running up on the end of our presentation here, but since I have a couple more minutes with you, I did want to take this opportunity, like I said, just to highlight really what are the 2 biggest issues we see facing agents and brokers right now in trying to navigate an incredibly competitive and difficult market for buyers and sellers. The first is both buyers agents and sellers agents not really understanding how to write or accept non-contingent offers. If you're familiar at all with C.A.R's contracts, we have a laundry list of buyer contingencies typically. Buyer gets into contract and then they have a due diligence period. They have a period to make sure they can get their loan, to get an appraisal, to do their inspections, review title, HOA documents, all kinds of things. And in most of the state, that's just always been the standard practice. I know up in like Silicon Valley and parts of Northern California that have always had an out of control market, that they've been writing non-contingent offers for a while. But in the insanity of the past year, this practice has spread statewide. And we've seen agents and brokers who've never done this before attempting to handle non-contingent transactions, and not on the buyer side, not properly advising their buyers what it means to waive their contingencies, to waive their due diligence periods and rights, and buyers not realizing that by doing this to get the offer accepted, they lose their ability to cancel and get their deposit back if they discover something they don't like about the property, or if they ultimately can't get their loan on time. Even if there's just a delay in the loan and now they can't close, that buyer's deposit's at risk, which for a lot of people who scrape together the money to purchase a property can be pretty devastating. On the listing agent side, by far and away most common mistake we see is listing agents, sellers agents who don't know that a new disclosure of material facts or a late delivery of the transfer disclosure statement can reopen cancellation rights even in a non-contingent offer. So you'll have a buyer who writes a non-contingent offer, you get 3/4 of the way through escrow, the listing agent finally gets around to doing their agent visual inspection disclosure and provides it. Well, now the TDS is considered complete. Now there is a 3 to 5 day rescission right for the buyer per Section 1102 and per our standard contract that allows the buyer to walk away. So that can be a very costly mistake for listing agents who've assured their seller clients that the buyer's locked in, and then they deliver disclosures late, and that can blow up the transaction. So that's really what we've been seeing a lot of on that front. And then finally, this has always been an issue, but now more than ever, agents trying to creatively draft their own clauses to put into contracts. Obviously, our standard forms exist for a reason, and it's to try to prevent agents from engaging in the practice of law. And yet, we've been seeing a lot of attempts to creatively draft clauses to try to make offers more enticing to sellers. We've seen an increase in the use of escalation clauses, also called sharp bids, which are pretty controversial. It's the, buyer will pay $5,000 over next highest offer. Sometimes that's all they write, and it leaves open a lot of room for interpretation. They often leave out a cap, which is understandable from a negotiating standpoint, but a very bad and risky idea in this market. And often they don't realize they should ask for proof of the actual other bona fide offer to make sure that they are competing against another valid, legitimate offer in the bidding war. And then the number one problem we've seen, I would say, over the past year is people trying to creatively draft clauses to address low appraisals. When the market is moving as fast as it is, appraisals and comps don't really catch up on time. And so you have these bidding wars where a property will sell for 50 or 100,000 over the list price or even more. And the buyer will, in some cases, waive the appraisal contingency. And then now they are locked in to make up that price difference between the appraisal value and their purchase price. Or what we've seen is people will write in language that is usually something pretty much exactly like, buyer will pay $10,000 over appraised value. And that's all that it says. And the seller thinks that means, well, if the appraisal comes in 10,000 low, the buyer will make up the difference. The buyer thinks, oh, if the appraisal comes in low, the purchase price will be reduced to $10,000 over whatever the appraisal is. Nobody agrees on what that means. No one can agree on what they thought it meant at the time. And then everybody sues everybody. And so it has just been a real uphill battle trying to educate and remind agents that just not to be drafting these clauses, not to trying to get too creative. If their client has creative ideas, that's when it's time to bring in an attorney, have them write up an addendum for you, have them draft up a clause, and don't have agents trying to figure it out for themselves. And that's it. It's at the end of our time.
Thank you, Jana. Just to mention, I have had occasion recently to look at transactions up in Seattle, and they are doing them only with these escalation clauses primarily, and all in the contingencies waived. And so you're on this edge of your seat waiting to see what you're really going to pay. And once that comes in, usually there's no contingencies left. and they're doing that, and they have forms up there of their own that they use for that.
Yeah.
Secondly, someone was asking if we're going to see a lot of COVID-19 changes to leasing forms when your new forms come out.
Yeah, so definitely. So I did not talk about COVID leasing forms today because that's probably a 3-hour long presentation in and of itself. We have been constantly updating all of our leasing forms every time the COVID-19 Tenant Relief Act is extended. And right now, it was most recently extended again till the end of September. And then starting in October, we're supposed to be entering something called the COVID housing recovery period. So absolutely, you will be seeing, we're working on it right now, the revisions to mostly to our notice forms, the notice of termination of tenancy and the pay rent or quit forms and things like that to comply with the COVID rules and restrictions.
How do these fire hardening rules come into play when you have a common interest development and the land around the properties are possibly owned by the association or they take responsibility? And what we're seeing now sometimes is some people are pushing tenant in common purchases where somebody takes an apartment building, sells it as tenants in common, and it's not really a condo association. So how do you deal with these fire hardening requirements and disclosures and when you don't actually control those common areas?
Yeah, I would say that is the question raised by this law, to be totally honest with you. What I keep sort of mentioning is that this is one of those laws that was written to be tied to a real estate transaction, clearly by people who don't have any experience with how real estate transactions work. There's absolutely no discussion. I mean, this law technically applies to condo units, but a condo unit, the individual owner, they're not responsible for home hardening features or frankly for defensible space around the exterior of the building. So common sense would indicate that the homeowners association, I mean, the defensible space laws, at least, those laws just exist separate from, this new law is to ramp up enforcement and getting documentation of compliance. But the laws are already out there saying that property owners are supposed to maintain defensible space. So theoretically, the HOAs should have been doing that already. And then I think for the home hardening aspect, when you're selling your condominium, the argument would simply, or not the argument, but the application would simply be, well, I don't have control over the common area and I can't do anything about the home hardening elements.
I suppose if you're in a tenant in common and say 8 people all own this building together and people running it aren't doing the preventative measures, you could be personally still liable if there's a problem with these things.
Yeah, I think that is absolutely a big risk of that tenant in common formulation.
Finally, somebody said that they've had transactions where they couldn't get the certificates in areas like Santa Barbara. And they're saying if you talk to CAL FIRE, it might be interesting to find out when they'll be available in all these other areas.
Yeah, no, I've heard that as well. And we are definitely in constant communication with them, asking about what the plan is for that, because that is the feedback I've had from realtors across the board is we can't get anyone out. We can't get an inspection. We can't get a certificate. And we are assured that, now the laws in effect, they're really going to ramp it up and be more efficient. But that's, that's just what we've been told. And I haven't quite seen it yet myself.
Sorry we ran over here 5 minutes. I have a very big thank you to Jana, and I want everyone to know that I've had a lot of experience dealing with the lawyers on the C.A.R. hotline because I was on their alternate list and for about 25 years taking calls from agents and brokers and advising them. And they do a great job at C.A.R. I almost always agreed with the advice they were giving people when I heard about it. And they have people like Jana who are obviously very knowledgeable and they educate themselves on an ongoing basis. And when you have agent clients and other people asking questions, you may want to refer them to the C.A.R. hotline if they in fact are members, or the agents and brokers are members of C.A.R. Because it's very useful. And then finally, a thank you to our technical staff at the Beverly Hills Bar for helping us out with the program today. And thank you all for attending. I hope that you've enjoyed this, and you will get a chance if you want to do an evaluation of this program, I think, when you get your MCLE certificate. Thank you, and we will see you again September 23rd for our commercial leasing program. Thank you, Jana.
Thank you.